We have separation. Inboard and outboard, they're on. I'm coming forward with the side stick. I've got a blowout. Neighbor 3. Pitches out. I can't hold altitude. Correction. Alpha 4 is off. Flight emergency. Flight call. I can't hold it. She's breaking up. She's breaking.
Hey guys, good to see everybody. Just want to say hi to the people in chat first. We're back to our kind of core group numbers. For those of you guys that are out there that are new to this group, what we want to do is just take a cool-headed approach to things, try to be objective, and try to respect everybody's opinion, as long as it's rational and logical, and as long as you're seeking the truth. And we all make ourselves learn better that way by doing that. So good to see everybody. Tom, good to see you. My man, he's down in Florida right now, sitting on a porch where his fishing line can reach the water, where there was a shark going by this afternoon, probably with a beer in the other hand. So a fishing rod in one hand, a beer in the other hand, and a fridge not far away. So that is pretty close to paradise. Colin, good to see you up in Canada. Hillbilly Nitro, good to see you. Kathy Chapin, thank you. B. Tim. Judy, good to see you. I hope Marlena's doing good. Ranger Joe, it wants to know how my taillight theory is working out for you. Well, just so you know, Ranger Joe, free Karen Read people are welcome here. Everybody's welcome here, as long as you're respectful. And we do read your questions and your opinions. Obviously, sometimes the numbers get high here and it becomes hard to read the questions. So we do, if it gets like that, I'll look for them. I spend a lot of time at the end trying to read them. But you'll get your chance. Griff says, you still have time, Kev. You're a lot of things, but stupid isn't one of them. Well, thank you, Griff. But I am going to focus and trust in the evidence and in logic and not get swept away by the latest things. If some don't, when I say swept away, don't get me wrong. If some important piece of information comes out right now and you guys report it to me, I will process it and it might change my opinion on something, but we'll see. Okay, Jeff, good to see you, man. We're going to go over the hearing that from a couple of days ago. It's good to see it again. I'll do it at higher speed so we can get through it. Elaine, hi, good to see you. I'm going to do it at Julio Suave. Good. I'll do it at higher speed so we can get through it. But it's good to see this hearing again. This is the hearing from Tuesday, not the Turtle Boy hearing. I don't really have much interest in that. But the Karen Read hearing was fascinating. Had a lot of explosive new revelations in it. We're going to go over it, and when you see it again, maybe you process it a little bit differently. And then some of these things, I do have some new evidence to go over on that too. So again, thank you for being here. Please hit like, give us that support. And we've had a weird thing going on with the numbers. A lot of the people have moved from watching this on YouTube to watching it on Twitter, which is obviously fine. But we have an interesting aspect of that is if you comment on Twitter, I see it here, but the people on YouTube don't see it, and vice versa. So I don't know. But one thing you could do, and I'll mention this again a little later, is if you have a chance, sneak into YouTube and hit the subscribe button. That would really help me out because we're hoping to hit 5,000. And it's very hard to do that when you're not on the conspiracy side things. If you're on the conspiracy side, you get big numbers, but you don't if you're just trying to be the steady at the wheel approach to things. But so I'd appreciate it. Okay. Got a couple of videos to show you today. There's a lot of excitement out there, nervousness, anger, frustration, depending on what side you are. It's kind of reaching a feverish pitch now, right? In this Karen Read circus. So we're going to be the calm in the storm, you and me. We're going to make it all zen in here. We're going to continue to rely on our old standby, logical analysis. That will be our guide. And months from now, looking back, we'll be very glad that we stayed calm and stuck to a logical weighing of evidence. The Karen Read case got way more interesting this week for all kinds of reasons. Did the trooper mislead the grand jury? Are the feds the ones acting corruptly here? So you can pick your side, right? There are things you might look at and say, I don't trust the Mass State Police, or there are other things you might look at and say, I don't trust the feds, or maybe you don't trust either. So we can look at that a little bit. Is 227 now back on the table? Did Alan Jackson use more trickery? Is Adam Lally a liability or a secret weapon? Will we see a different Jackson and Yanetian trial? Did we learn anything that impacts the fundamental logic of the case right now? Let's not forget the human costs here. John was raising his nephew and niece because their parents had died tragically 8 years before. He'd been enjoying the bachelor lifestyle when that happened, but he stepped up at the hour of his family's need. He gave up that bachelor lifestyle, gave up most of his career ambitions on the police force. It's hard to be a father and have career ambitions. Those kids now had an inexperienced dad and no mom. Into that breach also stepped two generous women, Kerry Roberts and Jen McCabe. Kerry actually knew John from his hometown of Braintree. People don't know this, but she wasn't connected to the Alberts or the McCabes. In fact, she met Jen for the first time that morning. Yet now she's accused of inventing things that she heard Karen say in the car. She's part of the conspiracy, right? Jen has 4 daughters, similar in age to John's niece, and understanding the difficult situation that they were in 8 years ago, she became an active presence in their lives, and she still is. Yet those kids have to listen to half of their town saying Jen helped kill her uncle. So let's just keep in mind the human costs here. This conspiracy stuff isn't just fun and games. These are real people, okay? In a minute or two, I'm going to go over the hearing, and we'll speed it up so we can sail through it. But first, I want to point out that none of the fundamental evidence in this case has changed. I want to first consider very briefly another current case. This is the Delphi murders of Abby and Libby, because there was a new motion out yesterday from the defense, and there's a lot of interesting stuff in it. I'm not going to go over that tonight, but I think I'm going to do a show on that Saturday, because there's some interesting ways to compare this case to the Karen Reed case. So I just want to go over this really, if you'll indulge me, for a couple of minutes here. Let me bring this on. I have this in here. All right. And maybe I'll try to speed this up too. But so this is a recreation done by Gray Hughes that matches up perfectly with all the evidence that's known. All right. So these are 3 girls that were walking away from the bridge. Okay. And so the killer has not arrived yet, the alleged killer. I'm trying to speed it up a little. All right, that's the alleged killer right now driving by, Richard Allen. And so these 3 girls are adolescents. There was actually a 4th one there too, but because she was really small, they didn't include her in the information. But these were like 12, 13-year-old girls. Richard Allen sits in his car for about 10 minutes, and then he gets out of the car. And parking up there was not a parking spot for this trail, so it was an odd place to park. He goes by the girls, and so he describes them, and they describe him. So Richard Allen, later on, a couple of days after the killings, he went and turned himself in to do an interview with a conservation officer, because we don't know why, but maybe he suspected someone had seen him there. And so he described everything he saw, including those 3 girls. Now, and they described him. Now, this is a young adult woman who, and you'll see right behind them is Abby and Libby. So they're just a couple minutes behind. Oh. For some reason that stopped. Hold on a second, let me catch up to it again. All right, so I got a little head there. All right, so this girl right here, this young woman, sees Richard Allen on the bridge, thinks he's creepy, so she turns around. Richard Allen sees her too. And they're all describe him in the same clothing, and he describes himself. Now, this is Abby and Libby. We don't know if they saw him there or not. We'll never know. But they get to the bridge. He's either turned back or is hiding in the woods. And they start to cross this bridge. It's like a 700-yard long bridge, and it's an old crumbling railroad bridge. So you see there's a little picture there. It's hard to tell just how crumbling it is though from that picture, and it's very high. It's like, I don't know, 100 feet over the water or something like that. And so Richard Allen, they're still on the bridge here. The bridge is just not on the bridge. Not only is over the water, but it continues over this long stretch of woods. So everything right there is bridge that they're on, and Richard is coming up behind them. And the girls get to the end of the bridge. They see they see the bridge guy coming. That's the picture that Libby takes. And he gets there and he shows him a gun. And we actually now know that we know that Richard Allen, that we know that the girls are caught on the audio, or say on the audio, is that a gun. So they did see a gun. He marches them down, marches them across the river, and right here is where he kills them. So I told you guys it'd be brief, and so we get out of that. But so there was other evidence. So his own words put him there, and no one else there. And several witnesses saw him there. And then after he killed the girls, he walks over he makes his way to the road, and another witness driving sees him, and she describes him as bloody and muddy and looking like he'd just been in a fight. Now, she didn't recognize him, she doesn't know him, but she described him. And he puts himself at the scene, all for the exact time when he spent an hour and a half with the body. So, and he puts himself 5-6 years ago when he spoke to the investigator at the time, he said he was there exactly at those times. So, I mean, his own words really sunk him here. We'll never know why, unless he explains at some point, why did he go speak to the conservation officer? But we think it's because the town of Delphi is under 2,000 people, and he worked in kind of a prominent job because he worked at the time at the photo counter at the CVS. So there wouldn't be a lot of stores in a small town like that. So a large percentage of the people would recognize his face. So he probably was worried that someone had recognized him. So he figured better off getting down there and kind of, trying to control the narrative a little bit. But they also found an unspent shell right next to the girls' bodies that was matched to his gun. And then this past spring in jail, he actually confessed on the jail phone to his wife, and that is admissible. Now, we don't know what else they have. They did search his house and took a lot of items. Did they find any evidence? They have his phones. They have his car. Was there blood in his car? That's stuff that, as we're seeing in the Karen Reed case, you'll see in all these cases, the prosecution will hold a lot of this stuff back until the trial. It's in discovery, so the defense team has seen it. They know everything that the prosecution has, but the defense team is not going to talk about any evidence that's going to implicate their client. Now, this document that came out yesterday is a motion by the defense that's complaining about a lot of things. And this is what defense teams do. And these aren't a high-priced defense team. These are public defenders. But they've come out with a very aggressive strategy to say that an Odin cult did this, that Richard Allen was completely a patsy and had nothing to do with the killings, wasn't aware of them, and that even his confession was forced out of him by a couple of guards in the prison that were supposedly part of the Odin cult. So it's a pretty wild stuff. But when you read what the stuff is complaining about now, it's reasonable. So there are documents that are referenced. This was a large, any investigation is large, but this one was truly massive. And there were documents that are referenced in other documents that the prosecution has gotten through the discovery. But those documents, even though referenced, never showed up with the discovery, right? They were phones that were picked up on the geofence that was taken near the crime scene at that time, where some of the people that showed up in that geofence were not seemingly interviewed by law enforcement, and there's no notes. For some reason, it looks like law enforcement dismissed those people as suspects. So, I personally suspect you can find things like this in any large investigation. So, I mean, for one of the things was that, or just imagine this. This didn't happen, but let's say a hypothetical. Imagine that one of those phones that was picked up on the geofence was by someone who happened to be friends with the sheriff. Aha, right? Well, maybe, but no, not at this point, because the fundamental evidence against Richard Allen is still the fundamental evidence. Now, maybe these phones picked up the geofence picked up any phones that went within 60 to 100 yards from the crime scene where the girls were. Now, they're out in the woods, but anybody that was fishing and walked along the water for any reason would have been picked up. Now, it was winter, but the water's only a foot deep. I don't know if anybody was fishing at that time. I'm not sure if the bridge was within 100 yards, it'd be close. There was also there's other trails down there. So, and it's a popular area that people are walking around in. Where the girls were slaughtered was kind of on a riverbank or a creek, really. And so it was very sheltered. So it was a perfect spot to do it where you couldn't see them from the bridge. But there probably were people that walked within 60 to 100 yards, and then the police investigated them and dismissed them for one reason or another. But you could see where someone looking at this here, a defense team, is going to really shine a spotlight on that, right? And they can be very tricky with the things they say and make something look like it's duplicitous on the part of the police. You have to be really careful for that, because that's always going to go on in these cases, especially with high-priced defense lawyers. And it's very easy for us to get fooled. They employ a strategy that I call odd things. Now, odd things really draw our attention because we don't like things that can't be explained. Odd things can be very important, of course, but they can also just be odd things. And there are always going to be odd things. They can be things that have nothing to do with the fundamental evidence. Now, in the Karen Reed case, there are some foundational pieces of evidence. These are things that are really hard, if not impossible, to get past. One is this: John never went inside that house. And we can argue about all kinds of things about this case, but GPS is very accurate. It's a location tool. It's designed by the military to fly a missile through a window. Satellites are put in orbit just for GPS. And there's a chip on your phone or in your car whose only purpose is to grab that satellite signal. GPS shows John's phone didn't go in the house. Now, Apple has a very nice exercise app, but it's not designed to send missiles through windows. No satellites have been launched because of an Apple app. Did John drop his phone and go in the house? That would be the only way, because the GPS isn't lying. But for that to happen, you have to imagine that he was intact inside the house, carried out, and dropped right on top of his phone, because that's how it was found. That's pretty hard to conceive. You'd have to have 11 witnesses lying, and none of them breaking when they heard the feds were issuing subpoenas to others in the house. Now, someone would break to save their neck in that situation. So I feel pretty comfortable in saying whatever happened that night, John did not go inside the house. He just didn't. That's just fundamental. The second thing is that there was really no opportunity to plant evidence, at least not the main piece of evidence. The only way to conceive of it, the only way to really imagine that main taillight piece, which was found at 5:45 that night, is if multiple troopers are involved. And this is where I actually myself really flipped late last summer, when I was finally able to learn where the SUV was all day and what time it arrived in the CPD garage and what time the big taillight piece was found. Now, I have good sources now, but I didn't then. What I had was just the basic evidence, which I didn't actually even get until late in the summer when I could finally get some documents. And I had logic. That's it. Now, we all have those things, but people get distracted by the odd things, like why didn't the Alberts come out of the house? Or why did Higgins punch into work after leaving the after-hours party? Not that those weren't interesting things. And if the fundamental logic of the evidence of the case wasn't so slam dunk, those things could be big things. But since the core evidence is so compelling, you have to be careful not to be distracted by the odd things. Don't dwell on the odd things when we have irrefutable evidence and logic. On a week like this, with things that seem a little explosive coming out, you have to stay grounded and trust in the fundamentals. All right, so let's do this hearing. Thank you for staying with me, guys. Appreciate your support. And let me just connect this to the hearing. And like I said, we'll do it at increase speed so we can get through it a little bit faster, but still clearly. All right. And let's do the speed.
Jackson for the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Unetti for Karen Reed.
Good morning, Ms. Tinetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right, so when we were last here on February 26th, I first anticipated that today would be for all motions, but I did read the very detailed affidavit from defense counsel regarding dates and what we should cover. And so today, as you know, I changed some of the dates to accommodate you, I think there was some short trial dates you may have had or restitution dates. And so you did get the order on the new dates. So today is only for filing all Rule 17 motions and for the motion to dismiss under Odell and the motion for sanctions. So I don't remember if it was Mr. Jackson or Mr. Yannetti who last time said that I was operating from a blind spot because I didn't have the information that was disclosed to you folks from the U.S. Attorney's Office. So you were good enough to get me the entire packet, which I appreciate. I read it. I see now how the federal investigation began and when it began. I've also read the pleading. So the motion to dismiss.
So just want to say that's really interesting because now the judge knows how the investigation began. We don't know. Now, what we've heard from good sources is that it began just because Karen and her attorneys walked in to the U.S. Attorney's Office.
Pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also, I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, we expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings. So I've read everything. I'm going to give each side 10 minutes, and we're going to start with the motion to dismiss. So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So go ahead.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought the court said the last time we were in court, we had basically your word.
Yeah, all day. But that was when we had all the motions. But it's just these two motions
right,
today.
But they're big.
They're big. So
with
why don't you go ahead and start? If you need additional time, tell me. But it would be important to focus your argument. Again, I'm mindful of what the U.S. Attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
So just to look again, I'm not a lawyer here, but I think that what they're saying, what the judge is saying there is that you're only, the Odell motion is just to dismiss. And there are certain rules and there are laws and precedent that applies to what it takes to dismiss a case at this point. And as the judge pointed out, that's a very high bar to overcome. So there may be interesting things in the federal documents that could be relevant to other aspects of the investigation, but Jackson is not going to be allowed to discuss them. He's only allowed to discuss things that are relevant. But probably pretty much any bombshell would be relevant, I think.
Which means that
Right ahead.
I'll start with the basic rule of Odell. We start with the postulate that any distortion of the evidence, that's where we start. Any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say, your memo is very thorough and very helpful to me because you outline everything and same in yourself.
Thank you. The first point I want to discuss is what we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They have a long-standing, years-long relationship, and I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least, and there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some sort. Michael Lank walks out of the same bar or an adjacent bar. He'd been drinking with his buddy Chris. He walks out, stumbles out, announces to the participants in this fight that he was quote unquote deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E
That's
attached
right.
to your memo.
And the reason this comes to a head, and the conflict of interest comes to a head, is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury, nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and asked, the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer.
I'm a little curious as to how Alan Jackson knows that the grand jurors were stunned. Is that how could he possibly know that? But
And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury.
I mean, Officer Lank was in the house. I'm not sure the exact time, but it was very quickly. So my understanding is Jen McCabe, after when she couldn't get through to Brian and her sister on the phone, she went into the house, which turned out to be unlocked. And she went up and woke up Brian and his wife. And then when she came back downstairs, Lank was already entering the house or something similar to that. So he was in there within minutes. You know, not necessarily surprising that the root cops who had just been out there for the 15 minutes before that, dealing with in a blizzard, trying to save a man's life. Of course, let's be realistic. I'm sure they understand that that's the homeowner of Brian Albert, who's a Boston cop and whose brother was a detective on the Canton police force. But I don't think it's anything suspicious that they waited for someone who was basically like a supervisor to come in and go inside the house. Alan Jackson is making it seem like that's some crazy suspicious thing, and I don't think it is.
Sergeant Lank is a longtime childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years-long close family friends.
It should be kept in mind that whatever comes out of this, or whatever problems people have with what Michael did or didn't tell, he was just next up. It wasn't like there was a special, we got to call up and get this guy assigned to the case. There was nothing like that. He was just next up on call. His number was up to get called for this case. And that's in evidence. The state submitted that.
With the Alberts, the Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying...
I don't want to interrupt this too much, but it's Michael Proctor's sister that is friends with Chris Albert's wife. And as we'll see, the feds went deep into Michael's messages going back, and they apparently found, based on what we're seeing here, they apparently found nothing connecting him personally to the Proctors or the McCabes. Nothing. So that there is a little bit of a connection. I'd say more than a little bit. There's a strong connection between his sister and Julie Albert. So Alan's going to overstate it, but let's not. That doesn't mean it doesn't exist. But he's going to obviously overstate
September
everything.
16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors, and we've been rebuffed at every single turn. Newly uncovered text messages, but from the feds, revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that.
Just note the way he worded that there. Now, we haven't seen these messages, but you always have to, he's very Clinton-esque in the way he words things, okay? He had a conversation. So that doesn't mean that Michael Proctor requested Julie Albert to babysit the kids. Maybe he did, and we'll see in the messages. I don't know. But what I would guess happened here is that he messaged his sister saying, do you know anybody that can babysit the kids? And then she probably suggested Julie Albert, and it never happened. They never did get her as a babysitter. But so he makes it seem like Michael Proctor here said, hey, what's Julie doing? Can she come babysit the kids? And I don't think that that's what happened, or he would have said it.
Sink in for a second.
So yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody look the other way.
As I said, I'm not trying to take sides here, but if you really parse every word that at every chance Alan Jackson can, he walks right up to the edge of what we would call a lie. Walks right as close to it as you can get. In order to, it's distortive, and it creates false impressions. It's going to get way worse than this. And again, that's his job, and that's why he's a multi-million-dollar a year lawyer. He's good at doing that.
As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words, because we didn't create anything. And there's more. On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift. Michael Proctor didn't respond with, that's inappropriate, these are witnesses, these are potential suspects, please tell her don't ever do that again, don't ever suggest an exchange of gifts again, that would be inappropriate. I'm going to go write a report, I'm going to turn it over to Mr. Lally, and Mr. Lally's going to turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife. In other words.
Okay, so I mean, I think anybody fair here would say that's probably some bad judgment. Anytime anybody uses the word gift with a cop, or anytime a police officer, someone uses that word with them, they should distance themselves from that as much as possible. I think if you've watched enough movies and TV shows and stuff, imagine you're pulled over on the street and you want to bribe the cop. You're not going to say, officer, do you mind if I bribe you? You know, it's going to be something more clever, right? So you could almost say, like, all right, there's nothing. Using the word gift is kind of a weird choice of word, but it's also, if it was corrupt, you'd think they'd be a little more clever than that. But I mean, I think the bottom line though is that there's no evidence that the investigation was corrupted. The feds dug really hard into this, and there's no evidence that it was. But the most important thing for me is, so this summer, I did a lot of videos and I was fully on the fence. And one of the things, even when I leaned towards conspiracy, because I was told 227 was a reality, that search, that for me, I never could understand what motive there would be here for Michael Proctor to plant evidence. There's a big difference between looking the other way on a crime, because you can't get in trouble for that. But if you plant evidence in a murder case and you get caught, you go into jail for a very long time. And this was super high risk because the planting would have taken place 16 hours after the actual murder. So super high risk. And so nowhere was any kind of motive established, no, it's even close to justify that. However, I didn't dismiss it this summer because there was always the unknown, right? I don't know Michael Proctor personally. I don't know Brian Albert. So was there some tool that he had that was so powerful that could make somebody risk everything to do that? So I couldn't just completely dismiss that idea. But for me, it came down to the fundamental impossibility of planting evidence or something very close to that. Karen's SUV was in John's garage after she hit John, or if she hit John, but as she allegedly did. Then she took it out at 5 to go look for John and then go to Jen's house. And then Kerry and Jen, she called Kerry. Kerry just met Jen for the first time, so she must have got the address but she met them at Jen's house, and then they drove Karen back to John's house to see if he had returned. And they put the car in the garage. So again, the car was in the garage. Nobody's broke into the garage. At that point, the niece is home and awake and worried about her uncle. And within an hour, the grieving family started to arrive. So there was no chance to tamper with that SUV in the morning. Then Karen's dad picks her up at the hospital, and he drives Karen and the SUV to their house in Dighton, 45-minute drive in the middle of a blizzard. In Dighton, it's parked in the driveway under a Ring video camera, and it's a blizzard. So there's like, I don't know, 16, 18 inches of snow in the driveway as that piles up during the day. So there's no indication that anybody went and tampered with that vehicle while it was in the driveway. So then it's towed at 4:18. Again, 45-minute drive, blizzard, rush hour. We're not sure exactly what time, but it arrives in the Canton Police Garage sometime after 5. The main piece of evidence was found at 5:45. It had to be dug out with shovels. So we don't know the timelines on exactly when the search team started searching at 34 Fairview, but when they did, there's news footage of it. They're all walking out with shovels. So this piece was buried in the snow and had to be found. So, and how early did these guys have to get there to set up for their search? I'm going to guess it's at least an hour. They've got to set up searchlights, and there's news crews who are there. So to me, if somebody was to take that piece from CPD garage, a 5, 6, 7-minute drive over to 34 Fairview, the earliest they could get there, and this is if everything goes Mission Impossible well, is 5:15, 10, 20 past 5. And so you get there, and now you've got a pretty crowded site. And now you've got to bury this piece. And that to me was where I concluded that there was no conspiracy here. And nothing has ever come out to change that. Nothing. And you can go back to all the odd things that you want to point to, reports of odd things that may or may not be true. Did Brian Wanless of the CPD help remove a taillight? I doubt it, but a lot of people believe it, right? But even if he did, it has nothing to do with anything. It doesn't explain how that large piece of Karen's SUV was buried in the snow at the scene. It doesn't explain how there was a piece of John's cocktail glass found in the bumper, or a hair or DNA match and things like that. It doesn't explain any of that. So let's go on.
Get the gift from my wife, it'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February 1st, 2024. Now let's fast forward 2 years later. Now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about.
Well, the quid pro quo also requires the quo. And there's no evidence of a quo here. And actually, there's no evidence of a quid because no gift was given.
That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert.
So if Alan is telling the truth here, we've all speculated on both sides of this case whether there was a larger federal investigation that this got swept up into. But according to Alan there, and the judge has already said she knows how it was launched too. According to Alan Jackson, this thing was launched specifically for Karen Reed
family. And he admitted to an AUSA under very intense questioning that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Butnik, all of this before Yuri Butnik testified at the grand jury and before he and Butnik actually interviewed Chris Albert.
So what he's actually saying here, but trying to make it seem more devilish than it actually is that Proctor didn't hide his relationship with these people. He told his superiors and he told his partners.
Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Butnik testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand.
No, it's not. I mean, it's so ridiculous. We may find problems in some judgment here, and we'll talk about the internal affairs investigation and all that stuff. Fine. But that's just bullshit because there's no evidence, and the feds would have revealed this, that Michael Proctor had ever met Brian Albert. And there's no evidence that he had his phone number. So yes, that means a formal introduction would be required. Now, Michael Proctor had met Chris Albert maybe a few times or something like that over years. But he did require a formal introduction to the other people.
And jurors. Yuri Butnik knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a...
It's not a lie. Michael Proctor did not know Brian. And there's no evidence that they did. There's no pictures of them together. There's no there's no phone messages. The feds dug deep. They would have. Alan Jackson would be talking about those phone messages right now.
Concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Butnik, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the assistant United States attorney, Proctor was caught in his own web of deceit and testified as follows, quote, so this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny.
Okay, so he may be guilty of minimizing his relationship to the grand jury. That's not perjury. That's minimizing. Just like Alan Jackson is certainly guilty here of maximizing these relationships. It's a matter of point of view.
Scrutiny of a federal grand jury admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means
minimizing is not lying.
The evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so your time
No evidence was distorted.
is up, which includes me interjecting. Do you want 5 more minutes?
If I could
Yeah.
employ the court.
I'd like you to sort of get to the questions I asked as well. All right, I know you're reciting the evidence that I've read, but so I'll give you 5 more minutes. Go
Thank
ahead.
you. I want to shift gears to another example or another series of examples of evidence that was distorted before the grand jury. And that deals with the use of, or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert and the fact that
that's just another out and out lie, which You could maybe argue that Alan Jackson doesn't know this because he's not familiar with Massachusetts law or policies, but I doubt it. In Massachusetts, any kind of a suspicious or um, violent death like this automatically goes to the state police, with the exception of the towns of Springfield, Worcester, and Boston, who have large homicide departments. But in every other town or city but those three, even towns like Lawrence, where I grew up in, or Lowell, or Fall River, it goes to the state police. So there was no situation here where this was taken away from the CPD because of Kevin Albert. It's ridiculous.
John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert. When that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found.
So we'll find out exactly what this specifically is, but it sounds again like a nothing burger. It sounds like that, they reached out to Kevin Albert for somebody's phone number, and he's going to call this coordinating and blah, blah, blah. And you're reaching out to get a phone number or something like that, or a text so you can get in touch with a witness. And remember, by the time he reached out to Kevin Albert, there was nobody involved in this, had any theory or idea. Nobody had any idea that John went inside that house until Alan Jackson submitted that theory concocted by the defense on April 12th of 2023. At that point, they were just looking at this as a hit and run case.
I want to turn to at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version.
This is where he's going to be. This, I don't know how to understand. It's how you cannot prosecute him for lying at this. It's hard to imagine you getting any closer. But we'll play it a little forward, but it's disturbing. So you have to really keep this in mind. I'm not talking about making a decision on whether you believe Karen is innocent or guilty. Okay? Stand back, be objective, wait for the trial. Great. We all should do that, right? But one thing that is without doubt is that Alan Jackson is creating falsehoods here. Okay, and I'll play this to show you, but it's extraordinary.
Of the Celebrite software. That's on them. That's not our fault. Certainly not Miss Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it.
I mean, it's almost unbelievable. And I just, how anybody covers this case, the other channels, the Grifter, Turtle Boy, Dylan, the guy in Wales, LTL, the young jellyfish there. I mean, everybody understands that the state used the most updated version of the software in 2022, the Celebrite software. All right. Rich Green for the defense did his analysis 1 year later in 2023. So naturally, your software is always updating. He used the 2023 software. And Alan Jackson is making it sound here like the state had some software that they could have got, but they didn't. No, not unless they had a time machine.
The right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job in extracting.
It's ridiculous. I mean, they could not have found that result with the 2022 software. Okay. Now something changed. Software is very complicated. And we're going to find out a lot more about that later from the guy who actually wrote. We're not going to fight it in this hearing, but the person who actually designed that software for Celebrite. And these things, so software is complicated, and sometimes these systems flaws show up once you go out and test them. All right. So I would guess that Celebrite has maybe adjusted some things based on this case. So, but there's no question that to say that they had the information that honestly, it shows how desperate they are. If their basis for the Odell here and getting this thing overturned is that the state had this information and didn't give it, yeah, they had that data in the phone, but there was no way, nothing was interpreting that 227 thing. No software was going to produce that in 2022. In 2022, the software reported that all of her searches happened at 623 and 624. And that's what now Celebrite now says is the truth. And that's what Jessica Hyde says is the truth. But if he wants to argue that the more recent version of the software is more accurate, okay, that's, he can make that argument. But you can't argue that the state hid something. And he knows that too. But he knows that the only way to get this dismissed is to make that false claim. So he does it. But keep that in mind, that everything he tells you, and today and on many other days, a large percentage of it is so shifty that it creates false impressions, and you have to be really careful.
And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022.
Okay, now this is fascinating, right? I mean, this is absolutely compelling stuff. Like I said, you have to really sometimes remind yourself that of the human costs with all the people involved in this, because if you turn that off and just focus on the intellectual aspect of this, it is really interesting, right? So now you're going to have pitched on one side, you'll have somebody from the FBI in Quantico. Presumably they have some of the best people in the world, right? They're going to say that they confirm that Rich Green, who is an unknown guy, that his search, that his interpretation of the Celebrite data was accurate. Okay. Again, we don't get to see what this FBI person in Quantico, what this analyst, what their report is. We're just going to go by Alan Jackson, who, man, if you haven't seen it by now, he's shifty. All right. A lot of things he says are very, very shifty. So until we see that actual report, we should really wonder what the FBI analyst really said on this. But for now, let's accept that this as a true thing, that the FBI forensic analyst actually has concluded that 227 did occur, the search for how long to die in the cold. So now you have the FBI and Rich Green on one side. On the other side, you have Trooper Garino, who's, probably not some high expert or something like that. But then you have Jessica Hyde, who is extremely esteemed. She's in her 60s. She's done this all her life. She is a professor at George Mason and she's one of the best of the best. But if that's not enough, they also have Ian Whiffen, who works for Celebrite, and that's the software everybody's using here, who is also going to say the same thing, that they're testifying for the prosecution, that this search did not take place at 2:27. That's an erroneous timestamp that this software can produce under certain circumstances. And in a blog that he did in December, not specifically about this case, but clearly because of this case, he explains how those erroneous timestamps can, from time to time, happen. And he's going to testify for the prosecution. And strangely, in this case, too, you get people like Olivia going around saying, no, Ian Whiffen and Jessica Hyde are actually going to testify that 227 happened. This is where you have to realize that people just no longer employ logic anymore, not even basic logic, because to think that the prosecution is bringing in people that are going to testify against their theory is not logical. It's not sane. It's not rational. Okay. So you could at best say here that 227 is at this point unclear. You have possibly an elite expert from the FBI on one side that seems to think it maybe happened. We don't know. But if Alan Jackson's telling the truth, and then on the other side, you actually have the guy who wrote the software. So at the I think an honest person just looking at this in isolation and without looking at the rest of the data and the evidence in the case would say, okay, maybe this is a toss-up. Maybe we need to know more. And we'll decide, we'll make a bet better decision after we hear these guys testify at trial. And also I have had some reports in the last couple of days that there is more evidence coming in that will end the 227 debate once and for all, and not in favor of Karen. But we'll see. But I want to say one more thing on the 227. There's always been an inversely proportional relationship. I identified this summer between the planting of evidence and 227. If no evidence was planted at the crime scene, if that main piece was not planted before 5:45 that day, then 227 could not have happened. Contrary, you could spin that different ways. If you could show with certainty that 227, the search for how long to die Nicole, did happen, then you could also say that evidence had to have been planted, and that piece had to have been planted. Because if Jen McCabe was actually searching for how long to die Nicole at 227 when her friend just happened to be either doing that or was about to be doing that, depending on which theory you buy into, then there's no question there was a conspiracy. And the only way that there could be a conspiracy here, the only way Karen could be innocent is if somebody planted that main piece of taillight before 5:45. So there is that kind of relationship between the planting of evidence and 227.
That fact, Your Honor, is no longer open for debate. And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today.
Well, so we don't know exactly what the motion that was filed to dismiss this is 50 pages. And she only gave him 10, 15 minutes to make their best points. If those are his best points, there is no chance that this case is going to be dismissed. No chance. And he knows that. So really what they're doing here is just trying to a kind of a trial run. Well, first of all, they're trying to influence the public because they know a PR campaign is a big part of this. But they're also maybe trying to lay the groundwork for possibly getting some evidence dismissed, maybe, right? I don't see that here, or something they might try to run by a jury or might not, depending on what they decide.
But the cumulative effect of this deception and all of it, this distortion from the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust, the ones that are supposed to protect our interests. And the law does not allow this sort of conduct to go unchecked. The remedy when this sort of travesty of justice occurs is established by the state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough. And I'll be surprised if I don't hear it today. But something suggests, based on the moving papers that we just got from Mr. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance. I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right, thank you. Mr. Lally, we're going to start with 10 minutes. If you need more, you need to tell me.
Sure.
And thank you, Your Honor. No, I think 10 minutes should be fine. I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as brief as I can. Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation on the McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of three elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And three, that the evidence probably influenced the grand jury's decision to indict. None of which I would submit the defendant has met their burden with reference to any of those three elements. Just addressing sort of the overarching themes of the defendant's motion. The defendant challenges, as he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a purported deception of Sergeant Lank's relationship with the Albert family. Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with the Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf, as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard at the time that Mr. O'Keefe is found. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card monte trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcripts, which clearly demonstrate and indicate that the defendant, Karen Reed, killed John O'Keefe. But they don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised. In reviewing the materials provided by the U.S. Attorney's Office, a couple things that I would note is, number one, they have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea. The other part that's confounding is that it appears that these...
It's worth just stopping for a second to point this out. This is just an unprecedented campaign, investigation, right? An unprecedented case where the feds never requested any evidence from the state. However, they were getting evidence from the defense who had discovery material. We have no idea what they got or how much or anything like that. So it's fascinating. And at one point we were thinking that maybe the feds were their only interest in this was to, instead of looking at the actual evidence, but to just do the interviews of people to make sure there was no corruption or connections. No, they did go and look at the evidence.
Materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear from the investigation that they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Mr. McLaughlin stated on the last date, these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians witnesses' testimony that we received, or transcripts of that testimony. All of them confirmed that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight, there was no dog attack, there was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent a year later. They testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear definitive statements on scene, that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home.
So these things are also difficult. I've never processed this much into the evidence. It's never really factored one way or the other for me. So Karen said at the scene, and we now know that at least 5 firefighters or paramedics overheard her say, I hit him, I hit him, I hit him. I never really factored that in because you don't know what she's saying or why she's saying it. Was she asking, did I hit him? Was she having a moment? I mean, it's hard to factor in things like that. So I never have. Also, if they're going to charge her with second degree, then that would mean malicious intent. And the grand jury is the one that upped those charges. So if there was malicious intent, then by the time of the accident scene, she'd really be in kind of cover-up mode, right? And I think we're going to find that there may be some other actions. We're just speculating here, but we may find that she turned off her GPS. There's some evidence to indicate that. We'll see what else is in there that indicates consciousness of guilt. But if you have consciousness of guilt, why would you be saying at the scene, I hit him, I hit him, I hit him? I don't know. It's hard for me to really make sense of that. So I've always kind of discarded it as not important right now. The other similar at the crime scene, at 34 Fairview, after she went back with Kerry and Jen and she pointed out the taillight. What exactly was she doing there? If she knows she's guilty, why would she be pointing that out? You don't know. There are different things you can interpret here. One is maybe she doesn't maybe one is she's innocent, right? One is that she doesn't remember what happened. Another thing would be, and this is where I lean towards thinking, is that she's smart enough to know that if you've hit someone, there's going to be physical evidence at the scene. There's going to be you don't know whether there might be video footage. There's data in your car and stuff like that. She knows that they're going to match it to her car if she hit John. So at that point, the goal becomes to make it seem like you had no idea. And so I've always thought that she kind of put herself in a role. She character acted. You said, how would you act if you had no idea that you hit someone? And I've always believed that that's what was going on. Well, not always, but for a long time, I believed that was, when I was on the fence, I thought that was one option. And as I analyzed the evidence and realized that a conspiracy really isn't possible, then I basically leaned towards that one, saying that I think that she played a role. She said, I'm going to play the role of a person who had no idea what happened.
On the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to text from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for 2 no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided childcare in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened. Lastly, get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate, but I'm not really sure why we're still even talking about this.
It's funny. After he said this, the zombies of the Free Karen Reed Horde were all saying, he agrees that 227 happened. It was crazy.
So why this is still a topic that they're pushing. Essentially what we have is, yes, what counsel mentions is there was one expert who was given 2 extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and the conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of those, as well as the senior technical analyst from Cell Byte itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that.
It's so strange that how many people were watch this hearing and come away saying that the defense, now that's it, they've proved that the search at 227 happened. I don't really get that way of thinking. I don't mind if somebody says, "Oh, maybe it did happen," right? Because you have competing experts. That's fine. But to listen to this and ignore the fact that the guy who creates the software says it didn't happen, and not at least say, that might count for something, I find it really strange. So you have people like Sean McDonough going on the air and saying, "It's over, it's over, it's over. This is 227 actually happened." I don't get it. I really don't get it.
But based on the totality of the evidence and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay. Do you want a few minutes, Mr. Jackson, to respond?
Very briefly.
Okay.
First of all, it's always interesting to hear an argument that suggests there's nothing to see here. That's exactly what Mr. Lally did yet again. He said, "Look the other way, look the other way." Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, "Oh, well, there's just a couple of text messages. It's no big deal." The fact is, Your Honor, she really hit him. She really hit him. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, "Oh, well, she killed him. Let's just get on with it. She killed him." He's already tried and convicted her in his mind and tried to do it in this courtroom. Doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car. Period. Full stop. That's their independent.
Okay, this would be powerful if it's true. It would be very powerful. I would say that if there is an FBI, well, he didn't say that he worked for the FBI. He said that this was an independent expert on this. And if they're presumably going to present this guy at the trial, and both sides will get to cross-examine him. But keep in mind Alan Jackson's trickiness with words. I mean, I've highlighted it already here so many times. Did this expert actually say this? I don't know. We haven't seen the report, right? But it's going to be crucial that the state does present to the jury a believable theory of what happened. But we don't know exactly what this we don't know who he is, and we don't know what he said. It is very interesting to me that the U.S. attorney is hiring an independent expert. How strange is that? How strange is that? How suspicious is that? The U.S. attorney. This is the only people over the U.S. attorney are the Attorney General, Merrick Garland, who's part of the administration, and the president. The U.S. attorney is a very high up position. Why is he so not only interested in this case, but seemingly determined to help Karen? That's the story that I want to know. That's the story that has to be told someday. And hopefully we have an honest enough government, which I doubt, but hopefully there are, what do you call, I forget what they're called. The IG, the Inspector General, the Inspector General's office will investigate this for the feds and also the ethics office and try to get to the bottom of this. What was going on? Was this on the up and up? So Karen can just walk in with her attorneys and make the U.S. attorney's office part of help them in their investigation. That's pretty compelling stuff. We know that they went in there at least according to what we found out today, in November of 2022, so long before any data was found by Rich Green, so nothing about 227 or stairwalking or any of that stuff. Okay, so we just had really very limited evidence on which to build a conspiracy at that point. Yet they were able to convince the U.S. attorney that there was something here. How'd they even get an audience with the U.S. attorney? Can you get an audience with the U.S. attorney? Can I? I don't think so. So it makes you wonder, does David Yannetti have a relationship with the U.S. attorney where he can just get in there and talk to him and say, I got a funny feeling about this case. Might want to look into it. And not only does he assign FBI agents to look into it, but it becomes a priority for him himself. As we saw here, he's the guy that questioned Proctor. And I don't know how many other witnesses, but at least some, that he's the guy that went in and prepared. That's a lot of work that this U.S. attorney was doing in this. Based on what evidence? And the messages that I've seen show that he actually was involved in this in August of 2022. So it goes way back before even this report seems to indicate. So what is, at least according to what Karen was telling Natalie. So this is just incredibly fascinating stuff. Now, if they find some grand conspiracy, then the feds are the good guys here. But as I've showed, the evidence is really almost impossible to overcome unless there was this vast conspiracy that involved multiple state troopers. And it's hard to imagine a conspiracy here. It really is. That's just, if you're just applying logic, forget about all the odd things that they throw around there. Just apply the essential logic of the case. And the core elements, stick to the foundation, and you'll see that there's no way for there to be a conspiracy here. But yet they convinced, was then at the time the first U.S. attorney, so he was right under, second in command under the U.S. attorney, Rachel Rollins. But he stayed on board as the U.S. attorney. And the first U.S. attorney is still an extremely powerful position. Wow, that's they were able to call in some serious chips.
Expert, not ours, not somebody on our payroll like Mr. Whiffen or one of their experts or Trooper Garino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally that
Mr. Whiffen is not on the state's payroll. Okay, Mr. Whiffen is exactly what you would call an independent expert. He works for Celebrite. He doesn't work for the state. So it's just another deceptive, really dishonest way of putting things. Whiffen is an independent expert. I don't doubt he'll get paid for his testimony. They all do. Just like the independent expert hired by the feds did. They're exactly the same.
car did not hit John O'Keefe, and John O'Keefe was not hit by that car. But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these two texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were in fact in communication with each other as early as 2020. And with regard to the 2:27 a.m. search, it's not a three-card Monty. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember, what they actually said was, Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well. All three of those searches existed in the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of.
It's just a remarkable exercise in dishonesty. I'm not going to replay it, but there's no question that the state did not have any data report that showed 227 at that time, and could not have, because the software had not been written yet at the time of the grand jury.
He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it. Deny this motion. We're talking about the integrity of what is the foundation of Massachusetts judicial system. And that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right, thank you very much. Mr. Yannetti, are you all set?
Yes, Your Honor, thank you.
So the same time, and let's see how you do with it.
We believe our witnesses. They are telling the truth. Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey.
So this is a basis for trying to get the case dismissed, or at least get Morrissey just taken out of the office of the DA. But you have to keep in mind that the DA Morrissey's statement back in September, as unusual as it was made necessary by the extremely unique circumstances of this case, where this defense team very deliberately, very consciously stirred up a rabble rouser and a blogger and created a maelstrom of witness intimidation. There's not any question that what Aiden was doing was witness intimidation. He stated the purpose on every show that his goal was to hound these people on the ends of the earth, basically, unless they change their story and come out and tell the truth. But that's, you're asking them to change their story. And then he set out to make their lives miserable, to damage their businesses, to scare them in their homes. There's not any question about that. Now, it's not that the defense told them to do that, but they stirred up this hornet's nest. They met with him. There were hundreds of phone calls between them. They had lunch together. They had a rolling rally where they went and terrorized these people in their homes. And if that's not witness intimidation, nothing is. So whether they're liable to a charge of witness intimidation, no, probably not. But clearly they played a heavy role in creating the circumstances in which those families went and understandably complained to the DA that you have to stop this. All right. And so he put out a statement to try to protect them, but that's it. He made no statements about Karen Reed being guilty. And all we asked you to do was leave the witnesses alone, let them testify, and let the jury decide. None of those witnesses have been or had been caught in any dishonesty. And you don't even hear Allen, Jackson, or Unetti say that they changed their testimony significantly from the federal grand jury back to the state grand jury.
To potential jurors in this case on that date. I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify.
I think he knows that if anybody's in trouble, it's these guys. What they've done is unprecedented. That you're going to have a lot of latitude given to defense lawyers to do what they have to do. So I don't know exactly what's going to happen here, but what they've done, the way they've conducted themselves is shameless.
Qualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal, as a result of his egregious...
Can I just interrupt there and ask you, are these going to be the same motion, essentially?
No. There's information and evidence that's been provided by the federal authorities, which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue. Mr.
No,
Kennedy.
it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that. But even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right. So when you file the other motion, I need you to include in your memo how that's different specifically from this. Not just the remedy, but how the basis of it is different.
Understood.
All right. So I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023, and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements. By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial, a desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never, in over 30 years of practice, have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence. And I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs that this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possess as public prosecutors. So for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why did he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence? And announce that we're trying to reassign the guilt that he's already assigned to her. Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting, they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the the U.S. Attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the District Attorney's Office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, 88 Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe?
Oh, thank you to Michelle for pointing out that I had muted my mic. I muted to let this go for a second, but just to remind you guys, it's not a lie when the state told the judge that they had received no confirmation from the feds about their investigation. They had received no confirmation. Now, they knew there was a federal investigation because the witnesses went up to them, went up to the Lally and went up to the DAs and said, well, we've been subpoenaed to testify. But that's not the same as getting confirmation. They sent out 5 letters to the U.S. Attorney's Office that were ignored.
And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
About 3 minutes.
Okay, yeah, go ahead.
Thank you. Indeed, Your Honor, Justice Jackson practically spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interview. The prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Reed convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that
I want to point out that this works both ways, and it works for everybody, right? Once you've staked out a position on something, it becomes in your interest that turns out the way consistent with what you staked out. So even somebody like me, right? You can say, well, I've staked out a position in recent months that Karen is probably guilty here. So then that creates a confirmation bias. And for me, it's not really important. I have nothing at stake. But for somebody like Turtle Boy, he has a lot at stake. You know, if this turns out to be that Karen Reed is actually guilty. But this also applies to the DA's office, right? And that's what Yannetti is saying here. But it also applies to the feds, to the U.S. attorney himself. This U.S. attorney now has a lot at stake. He did something undoubtedly extremely unusual, and getting involved in this case so personally and so directly, and not communicating at all with the state, not replying to their letters, working hand in hand with the defense, even having a conference call in November and asking them to get a delay in the trial, which all seems incredibly inappropriate. What was going on to go, so they have a lot of both. Everybody has a lot at
Federal
stake here.
investigation is still open. They called most of the Commonwealth's witnesses to testify, but they're not done. DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Reed is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end.
I don't actually, people have asked me about this, and that's the first I've heard of it. I don't know any details of it. I don't know if it's unusual or not. If it's hard to know if you're not a lawyer and you don't work in these kind of cases. So I really can't, on that one specific question about having an okay to destroy your phones, I really don't know.
The DA also, as my colleague has indicated, I'm sorry, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time. There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly.
A lot of suspicious activity. I mean, they probably don't know exactly what time they went to bed, but presumably the feds are very good. The feds are very good at getting things like phone records. So that's how they probably just actually that would have to be how they discovered that Brian called Brian Higgins, that Brian Albert called Brian Higgins. He doesn't say there whether Brian Higgins answered the phone, right? We don't know if they talked or how long. But if there was a conspiracy and if they were trying to coordinate getting Trooper Proctor or whoever to plant evidence, certainly he would have made more than one call. But it sounds like he made just the one call to Brian Higgins. And that could have been about anything. They were all out partying.
Announced to the public, we're telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice, with no vested outcome in this case. And it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case, and that is why I urge you to do just that in the interest of impartial justice.
All right. Thank you very much. Who's arguing this? You, Mr. Lally? All right. So let's start with Ken if you need more.
Thank you, Your Honor.
Boy, Karen looks very smug there, but I don't think this is going to go as well as she thinks. I don't know about the trial, but this, in terms of this hearing to get a motion, there was nothing even close here that was going to get this motion dismissed. So those are just, I don't know. We'll see.
And again, I don't think I'm going to need much more than that. Again, I know the court has reviewed all the materials, and I know the court is well aware of the standard, and it's a standard which I would submit just simply hasn't been met here. To characterize counsel's actions in this particular proceeding with specific reference to the media and saying it's different, I think is minimization to the highest degree. Essentially, what the defendant is positing, or what counsel is positing in this motion, is that due to a recorded statement by the district attorney over 6 months ago, that impinges on her right to a fair trial, or it impinges, shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. It's also in conformity with Rule of Professional Conduct 3.6c, which allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again, I know the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated that the statements of counsel arguably cross the line of permissibility under Rule 3.6, and that meaning defense counsel. that the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case. And that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time, denying it without prejudice. And then Mr. Giannetti wants to get up here and say that they largely stopped making extrajudicial statements after the court's ruling. And so I guess largely stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Yannetti and Mr. Jackson were featured for a 9-minute, 37-second segment, in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think the confrontation got physical and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on and continued that this was a cover-up, and indicating that John was murdered inside that house, his body was placed outside. This also continued into September. September 17th, the defendant, traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer, to the victim's home, to Mr. O'Keefe's home, in direct violation of her conditions of release, where she has to stay away from, as well as other places of interest and sort of tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements, those particular actions go, as the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Reed on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti, and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023. And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the district attorney's office, the state police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous, is Disingenuous would be about the nicest term that I can come up with for that. Thank you.
All right. Mr. Yannetti, a short rebuttal, I guess, or a short comment.
I would just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that,
I'm not actually even sure what they're required to tell. Obviously, the DA is required to give any exculpatory information to the defense, and that's why in their letters you can see when they were contacting the feds, they were saying we need to have any potential exculpatory or inculpatory evidence that you dug up on this, where we owe this to the defense to get them any exculpatory information. And the feds just kept ignoring the letters. So I'm not sure exactly what Yannetti is even saying here. What exactly was it that they were supposed to tell? Just that the feds were looking into things? It seems absurd.
I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones in your
I
motion?
believe
with the
they're
container?
outlined. Yeah, they're outlined, Judge.
Okay,
Okay, we saw copies of those Rule 17 motions that came at the end of the day. People were posting them on Twitter. And so what they were looking for were the phones of, again, Brian Albert, but this time also Kevin Albert and Brian Higgins, and also Chief Berkowitz, or former Chief Berkowitz. So trying to find out what kind of communications might have been going on here that could indicate a conspiracy. It should be interesting to see whether the judge grants that. If she does, now we're looking at a delay of months, because these guys have lawyers too that are going to fight this. So it's going to, I would say it would delay this trial by at least a few months if she grants this. So we'll see if she does. She's going to be guided not by any personal inclination here. She does want to make the trial go on time, but she's going to be guided by precedent and rule of law. So, and I'm not a lawyer, so you guys will see what happens, and it should be interesting. I wanted to talk about Lally there briefly, whether people think that he is a liability or actually a secret weapon. So it's going to be really interesting to see in the trial, because jurors react very much personally to the lawyers. I've been on 2 juries. I've walked into the jury room, and the first thing a lot of people were talking about, I hate women, were what kind of shoes were the lawyers making, and how they felt about the lawyers made a big difference in how they felt about the cases. So how they feel about Lally versus how they feel about Alan Jackson and Yannetti is going to make a huge difference in this case. I think there's a chance that Lally is going to be a secret weapon, though, too. Now, yes, he's not as smooth as the high-priced Jackson or Yannetti. Yannetti's a very effective speaker too. He's not wearing an expensive suit. He is, as Turtle Boy coined him, Lunchbox Lally. So that could be a liability, and he's not always a guy that is forceful in his arguments, right? But that also could be a strength, because when you go before a jury and you have a guy that's just seems to be laying out the facts, and he's just a regular guy, he's not trying to score points, he's not trying to make $1 million, he's just doing his job. There's going to be a lot of jurors that are going to be sympathetic to that, and they're going to contrast it with Alan Jackson. Now, we don't know we may see a very Alan Jackson in the trial. I don't think he's going to do a lot of the stuff that he's done over the last year in this case, going out there like he did in this hearing here, and just really spinning outright falsehoods. I don't think he's going to do that in front of a jury as much, because when you spin a falsehood and then right afterwards the prosecutor just makes it obvious that you were spinning a falsehood, the jury's going to start to tune you out. So so we may see a very different Alan Jackson in the trial. I'm not sure. But he seems to have that flair for the dramatic. So we might see some of those stunts going on. And when he does that, does it have the effect of tricking the jury and maybe creating reasonable doubt? Or does it have the effect of pissing off the jury and contrasting Alan Jackson with Lunchbox and saying, this guy's just a regular guy presenting us with the facts? I think there's a chance that could be the case here, So it's really interesting to see how it goes. And it's really kind of cool to think about the different strategies here that could be effective. Because at the end of the day, you have to convince a jury. You got 12 people you have to convince. There'll be usually 14 people. There'll be 2 alternate jurors there. So there'll be 14 people sitting in the box, and they've got to convince them all. And they're going to focus on those. If you're the defense, you're going to focus on those ones that seem to be sympathetic to your argument. Now, if you get one juror that just won't go along, that does not mean acquittal. That means a hung jury. If the jury can't reach a unanimous decision, you get a hung jury, and then the state has the option of trying it again. And they will try this again. Don't even doubt it. After all the bad blood out there now, they will definitely try, and especially, a Boston cop that's dead. They're going to try this again. So you would have to convince enough to get it. It's not going to be easy to get an acquittal, but you may have enough reasonable doubt to get a hung jury, right? That's a lot more likely. To me, I don't think 227 is really back on the table, but everybody's going to have their own opinion on that. Also, I want to ask a favor too, if you guys don't mind. There's right now 862 people watching on Twitter, and I'm grateful to have you there. But I would like to bump my YouTube numbers so I can reach 5,000. So if you could just pop onto the YouTube link to this channel, or just go into YouTube under Yellow Cottage Tales and just go up and give me a quick subscribe, it would really mean a lot to me, because I would love to hit that 5,000. We got a long way to go on that. So if you don't mind, just if you're watching this later, pop into YouTube and just hit subscribe. It doesn't cost you anything. It's just subscribe. That's all it is. It doesn't mean I'm going to start sending you messages or anything like that. It'll just mean we'll show up in your notifications. And even then, if you stop watching us, the algorithm won't bring us to your notifications anyways. So that's YouTube's algorithms are like that. So another fact that we should probably talk about is it was revealed yesterday that there is an internal affairs investigation in the state police for Michael Proctor. So what does this mean? People are on the Free Karen Read side are very excited about it. Well, we don't really know for sure what it means, because just because they're looking into something doesn't mean there was wrongdoing. Certainly there was enough there to draw the attention of internal affairs that it's a relief to know that they do their job and they're going to look into things. That does not mean there was wrongdoing. That doesn't mean there'll be any kind of punishment or anything like that. It all depends on what they find. It doesn't sound to me that we've heard of anything here that would result in punishment. Okay, but we don't know. The big thing would be if he in any way didn't answer honestly in front of the grand jury, because then you end up on a giglio list, and it makes it really difficult to work in law enforcement after that, because you can never be in a position where you go before a court. They'll never put you in a job where there's that risk. So even if you're out patrolling highways, you'll end up in court. So you don't want to end up on that giglio list. And it's even hard to get work as a PI after that, because those guys go to court too. So, but at this point, there's no reason to think. And even if you kind of listen carefully to the comments there, and well, certainly Alan Jackson never at any point came out and accused him of perjury. So all they said was that he testified to the feds that he minimized the connections that he had to the Proctors. So I don't think that comes anywhere near the level of where this guy would end up on the giglio list. But Internal Affairs is going to look into it, and they'll see what else they find. To me, if they found something like that, you have something similar to an O.J. Simpson situation, right? Some of you guys may be younger and may not remember the O.J. Simpson trial. That was the trial of the century back then. And O.J. Simpson, we all know, was guilty. There was never any other suspects. We all know O.J. killed Nicole and Goldstein. I forget, it's Ron Goldman, I think. There's no question he did it, really. But I actually watched that trial back at the time and understood why he was acquitted, because there seemed to be wrongdoing on the part of the investigators. And so you have a situation like that. So worst case scenario, I think you might have something like that here. I'm not predicting that, and I don't at this point have any reason to think that that's the case. But the fundamental evidence is secure here. It's just not really possible for any of this evidence to create reasonable doubt. I mean, the evidence here shows that John didn't go in the house. So the conspiracy is really out. And unless somebody planted evidence, it was Karen's car that did it. And not only plant the taillight pieces, plant the main piece before 5:45 when there was no time to do it, burying it in the snow, but also the cocktail piece, the piece of cocktail glass that was found on the bumper, and the DNA that was found on the car. So there's an awful lot of evidence there. Now, where you'd run into an issue is if the state does not have a convincing theory as to how John died, how his injuries were caused, and how the damage was caused to Karen's SUV. I don't know how. It'd be very difficult for me to see a jury convicting unless you have a convincing theory. Now, Alan Jackson claims that the feds hired an independent investigator, and this investigator couldn't figure it out either. So we'll see. We don't really know. Like I said, Alan Jackson has a tendency to take a line in a report and turning it into something that it really isn't. Now, we don't know. But, Lally had a chance there to say, nah, he's all wet. The feds didn't find that. He didn't. Lally had a chance to say, we have a theory that we're very confident in, and he didn't. So I don't know. So to me, that is, when I had a chance to look into this with a source a long time ago, that was the only question I wanted to ask. Not what the theory was, because they didn't want to jeopardize the case, but just does the state have a theory that they're confident in? And I was told that they do, but that remains to be seen. So let me get to questions. Let me look briefly while you guys get your questions ready. Let me look into Twitter to see if there's any breaking news on this. Sometimes if I'm on for a couple hours, there's breaking news on the Karen Reed case. Don't really see anything coming up. Okay, so we'll just get to questions. We'll do that for a little bit, and then we'll call it a night. Thank you for being here, guys. Again, if you can, please go to the YouTube and hit subscribe. Thank you very much for supporting me. The approach will always be objective analysis of hard evidence, logical analysis of trying to piece things together, and that's it. And once that evidence changes, and if you missed the early part of the show, I said there's a strategy of defense teams is always going to be, look at this odd thing here and that odd thing there. Now, odd things can be relevant. They can be crucial, or they can be meaningless. And if you have fundamental, foundational evidence, then the odd things don't matter. If you don't have clear evidence, then you have to take a closer look at the odd things to see if there's another explanation. But in this case here, the foundational core evidence is very clear. All right, it's very clear. So you really can't fake GPS. GPS is a very accurate piece of information. Those satellites were launched specifically for that purpose. That chip in the back of your phone is a GPS chip. It's a special chip that is designed just to do that. Now, you will have weakening of signal, but that's also recorded. So when you look at your GPS, the normal margin of error is 15 feet, and you can be anywhere within that 15 feet. That's what the GPS that's what the GPS reliability is. But if the signal gets weakened by weather or by a building or a tree or something like that, we are out of range of all the satellites, it'll show up and it'll say, all right, the margin of the signal is weakened here, and now the margin of error is 100 feet. With John O'Keefe's phone, there was a 3-second period where the signal became weak enough that the margin of error extended enough to include the house. But you can see the actual pattern of where they drove and where they pulled up and where they parked at the far end of the property, which all the witnesses saw, and where John's body was found. So you're not going to really be able to get past all that stuff. A few people very generously supported me here. I want to say thank you to them. So Scott, thank you. Appreciate it. Appreciate your support. And I always like your comments here too. And he says, interesting information. Cheers for your work. And Carrie, always thank you for the conversation. She says, thanks, Kevin. I feel better. Buy yourself a gift. Don't mention gift. I don't want IA coming at me. So let's see if we have any more questions. Molly Killarney, Proctor called Karen Reed an anatomical slur. Yeah, I mean, we've heard that's too. So there's a lot of locker room talk, and these guys have their own feelings about things, and it's human nature. I probably, if you had the feds go into every case, you'll probably find stuff like this. Not defending it, just saying it's guys being guys, that kind of stuff. And we haven't seen it yet either, so we don't know. It wasn't brought up in the hearing, so it's just kind of rumored stuff at this point. So who really knows? But again, as I said before the hearing, you got to pay attention to what was, in addition to what's said, what's not said. And nobody said that there was any communication with Michael Proctor that morning by anybody connected to the so-called conspirators. So there's no way of seeing how anybody could have said, hey, buddy, need your help here. There's nothing there on it. So it wasn't Alan Jackson, who tries to take every little thing and blow it up into something, didn't mention anything like that. So there was no communications. And there's almost no communications at all between Michael Proctor and the Alberts going back years. They managed to find, what did they say, in 2020? There was 2 texts to Julie that had no content in them. So I think Jackson is probably correct that there probably was originally content and it's gone. But so that's it. So Julie was friends with Michael Proctor's sister. And so in all that time, all that resulted in was 2 texts in all those years. So there's not a close relationship there. But, even if there was, there was no opportunity to plant evidence. And that just kind of is what it is. That's where I was on this summer. I never had any of those, I now have sources on both sides, and I certainly have sources that are closer to the investigation now in that sense. Nobody gives me anything that's privileged or anything like that. But I didn't have those sources when I reached these conclusions around the end of August and early September. What I was looking for all summer was documents and couldn't get them. Nobody would share them. Turtle Boy doesn't share them. So none of us had them, right? Now it's a little easier to get these things. There's a couple of public sources where people post them in. And so once I started getting documents and you're able to look back and find out where was the SUV, and then you talk to people and stuff like that, I put that together by early September. And at that point I was like, okay, yeah, there's just no possibility of planting evidence here. So just looking at the questions, guys, thank you. I scrolled a little fast. I was trying to read someone's question. All right. So Victoria says, why was Ken Berkowitz at CPD at 5:42 wanting the bay doors closed? I've never heard that. So I don't know where you get that from. And you'll have to show me what that is. I've never heard that. And, and again, you have to go by what's not said. So did the feds find that? Because if they did find that, wouldn't Alan Jackson have talked about it? So I would check your sources on some of that stuff. If you're getting that from Sean, my God, how many times does Sean have to say something that isn't true before people learn? I don't really get it. I mean, I'm not trying to knock him. I mean, but you're out there on a channel now reporting things and going out on the people's shows and reporting things that even he knows are absolutely not true. So this isn't just about a theory of, discussing my theories and my beliefs versus his. No, he's reporting things that are not true, or were impossible. So like most recently when he said that Julie Albert called her brother for a ride because she had just seen John get attacked inside the house and wanted to get out of there. But so the brother came, but Brian Albert's wanting to control the situation said, "You send him off because you're staying here." Well, it was all impossible because John and Karen arrived at the exact same time as Ryan Nagel in the truck that came to pick up Julie. So she had called him many minutes before. It was impossible. So she could not have seen John attacked in the house and then called her brother because it was so it. And then when I pointed this out on my video, he changed his story. Now Sean knows that. He knows that John and Karen arrived at the same time as Ryan Nagel. He knows that. Maybe he forgot. I don't know. But so then he just, instead of saying, "Oops, I'm sorry, let's scratch that. That's a bad theory." He buys into it because, as Sean said, he's going to die on that hill. So then he says, "Okay, well, Brian Albert told them they were going to attack John." And so that's when she called her brother. But then apparently Brian wanted to make sure that she saw the attack of John. Why? I don't know, because that's absurd. But that's how he changed his theory to that. So that explains how Ryan Nagel arrived at the same time. This is how absurd it is. So if it's Sean that's telling you that Berkowitz was closing the garage doors at 5:42, and I'm not saying he is. I don't know who told you that because I've never heard that. But yikes. Have a little judgment about people that keep telling you things that aren't true or that are absurd. Kevin TB did call Proctor on his show, right? His number was in Jen McCabe's phone number. I don't know. Hi, Julie. Good to see you. James, thank you. We'll put his comment up. The extraordinary government misconduct is on the part of the feds, it sounds like, acting as Karen Reed's personal investigators. Yeah, it does seem like it. So unless they find some kind of grand conspiracy here, yeah, it looks pretty bad. It's very strange. And other people that I've talked to, former FBI agents, my college roommate who's now a judge, are just blown away. This doesn't happen. So it's extremely rare and unusual and inexplicable. Victoria says, I have a little recording. What does that mean? You have a recording of Chief Berkowitz ordering that? I mean, I can't take this stuff seriously. Kerry says that Sean just claimed Carl is involved. I mean, this is Victoria. Why do you take, as Kerry points out, why would you take this guy seriously? He's gone. He runs from one crazy theory to another. He knows. Listen, I tell you something. Sean knows Karen is guilty. On his lucid moments in the morning, I know for a fact that he knows it. But he's put himself in a position that he just can't back out of it. He doesn't know how to. Now, if it was me, I would just say, you know what, guys, I've been wrong and I'm sorry. That's what a man would do. I don't know. But he won't do it. So he accuses innocent people of things. So with us accusing first Paul and then Carl comes into play was Sean. And this summer when I was talking to Sean, he mentioned how there's not a scratch was found on John's SUV in the driveway, and which seemed inexplicable to him if Karen backed into it hard enough to crack her taillight. So he explained it away by saying that they whisked away John's SUV that day, the 29th, to an auto body shop where they could get rid of any damage to it and make it invisible. And I said to him, how is that possible, Sean, with the grieving family inside the house all day during a blizzard? Nobody noticed John's SUV missing? And he thought about it, and for a while, 20 seconds, I'd say. And then he said, Paul helped him. This is John's brother. So Paul was now part of the conspiracy. And over the subsequent months, he goes back and forth between thinking it's either Paul or John's best friend, Carl. It's crazy. It's so you're accusing innocent people of being part of a conspiracy to kill their brother or their best friend. Why? Why? Is that you want to die on that hill? That's what you want to go down as someone who's selling falsehood and smearing innocent people just to stick to a theory because you became a hero this summer? Because people maybe want you on court TV or something like that? Is that worth it? Is it worth it, Sean? It's not worth it, dude. Give it up. Judy says, if my friend is right, are you happy with this theory of how the trial ends up? She's talking to Bob C. I mean, we'll see how this trial ends up. Hopefully, we will have a trial. There's no question. I mean, unless there's a plea or unless some really strange reason the judge dismisses this case, which, trust me, she's not going to. Then we're going to see a trial, but we'll see how it ends up, right? There's still a lot of evidence we don't know. Usually you would think both sides have played their thunder now. The defense certainly has. Is there still important information that we haven't seen that the prosecution hasn't laid out yet? I think so, but I don't think it's going to be some slam dunk thing like for instance, video that shows the accident or something. No, but I do think we might find out, for example, did she turn off her GPS? There are indications that GPS was off. I also I watched a video today. It was, maybe I'll show it to you guys next show. It was pretty interesting. This is a news report where a reporter was looking into what kind of information could be got from Brian Kohlberger's car. And so she talked to an expert, and they went and they took out the entertainment center, which wasn't removed until December 1st in this case, because they had some problems with it. If they were able to get information from it, there are different, for example, there's a GPS in the car. There's a GPS chip. Not only, so if she turned it off on her phone, but there's a possibility they got that information from the car, if that software was not somehow corrupted or destroyed. So they might have that information from that. But it was amazing what they were able to find out in this episode that I watched. They could find out what time she got gas, what music she played, what phone calls she made, if anybody else got in her car, what their numbers were and stuff like that. It was amazing how much information the entertainment system in your car was picking up. So we'll see if any of that stuff comes out. Sean goes by the logic, if I say something enough, it makes it true. Well, the funny thing is he's enabled. He's enabled by people who don't question him. Nobody, when he made that crazy statement about Julie Nagel, nobody questioned it. Nobody on that side. That's why I say there's kind of a zombie horde out there. They don't really think about anything. Victoria says it's the literal call that Ken Berkey made to the CPD that's on the recording. I got it from a, okay, we'll share it. I haven't seen it posted anyway. I don't really, what you're saying that he called the CPD from home and said, close the garage. What exactly are you saying? And actually, wouldn't that be logical? So once the state police towed the murder weapon to that garage, wouldn't it be logical for them to make sure it was secured? And as part of securing that, wouldn't they want to make sure the doors were closed? So if Berkowitz did that, I don't find that at all suspicious. I would find it suspicious if they didn't do something like that. But, you think about it how you want to think about it. Keep it classy, Salem said. I've been to Salem for a while. I used to love Salem. You're talking about Salem, Mass, I assume, right? Great little town. I had a college friend of mine lived there, grew up there. His family was from an old part of Salem. They have this thing there, the Parade of Horribles. It was kind of a cool holiday. So if you're talking about that, Salem, that's cool. Do you believe that the Fed said the car didn't hit John and didn't get hit by the car at all? So we'll see. We haven't seen the report. We know Alan Jackson is a trickster with words. And so we'll see. If there is some kind, I find it very interesting that the feds would hire, like the U.S. Attorney's Office is hiring an independent investigator to help Karen Reed. It's really strange. But if they did, it will become, if they said something at all like that, it certainly will become compelling evidence that could influence a jury. So we'll see. We just don't know right now. Nor do we know what the state's theory is. And they have to have a legitimate theory on this. Scott Robertson, Kevin, regarding the 625 Google search, have you seen a precise timeline of where Karen and Jen were at that point? What time was Karen taken from the scene? No, I haven't seen that. I mean, they had to call a separate ambulance for Karen. No, I haven't seen anything like that. My understanding is there may be more information coming from Google or something like this on that, but I'm not really sure. Perry says chain of custody with the taillight pieces was outrageously inadequate. How do we know? How do we know? We haven't seen these reports yet. So you have to remember, we're seeing things that are injected into the conversation through social media by the defense or by allies of the defense. So, for instance, I think what you might be talking about are the little pieces that were revealed over the next week or so as the snow melted. There was some warm weather that came after this, so there was a lot of melting, and that's why more pieces became exposed on the street, or presumably all on the street. Maybe there was some on the lawn. I don't know, but presumably all on or near the street. And one of those famously was cited like 6 days later. Chief Berkowitz cited some pieces and called it in. I think either Michael Proctor himself saw other pieces later, or other people saw it and called him. And Olivia said these things were not documented. Aha. Well, if they weren't documented, how does she know about them? So obviously they were documented. And whether they were properly documented, I have no idea what that even involves. I mean, is this like finding bullets where all of a sudden you got to come in and put a little yellow flag there every single time you find a piece of glass? That seems a little unreasonable. You already have the bulk of the evidence, and now you're just finding more pieces to add to it. And it was documented, so obviously they have it. Salem says, if so, why didn't Lally contradict that? And it's a good question. And I mentioned it, and I did mention it. Maybe you got here a little just now, but I did say that Lally, to me, and I've talked that also privately to my sources, I don't understand why Lally wouldn't at least say, we have a theory and our experts have it, and we're very confident in it. You don't have to say what the theory is, just so you're not really revealing anything. So I am bothered by the fact that Lally didn't say anything to it. Heather says, you were so wrong for that stream. Absolutely dead wrong. Well, I don't know what else to do. I want to give people that are intelligent and reasonable a way to point out. So you can say in chat, but I don't, that's not a specific argument, so I can't say anything to it. Judy says, two powerful sides. No one's backing down. Yeah. Again, Victoria, you have the recording. I'm a little behind. So I'm reading these comments. I'm about 10 minutes behind. I'll try to speed up. But again, if Chief Berkowitz ordered the garage doors closed, isn't that what he should do? Shouldn't somebody have called up to say, make sure that you're trying to secure the location where this vehicle is now going to be closely inspected over the next few days by state police teams? So don't you want to make sure the garage is closed, the surveillance cameras are on, and anything else? All right, I will unblock you, Victoria, just to make sure. I want to be clear. I always have said many, many times on this show that I enjoyed my conversations with you, that you were one of the people that I always found to be respectful. Okay. And that's the truth. And that morning I'm exhausted and you're pumping me with questions, and you're not the only one. And I asked you about 5 times, please back down. You want to try the whole case on Facebook with me, and I don't have the energy or the time to do that with everybody. It takes up all of my time. And I was begging you. And I even said several times, please back off, because I don't want to block you. And I didn't want to block you. And you just kept pinging me with messages. And not just about one particular part of the case, but running all around with it. And it's so you're intelligent and I like talking to you, but I can't spend my whole life doing Facebook messages with people. It becomes overwhelming. I can't type fast enough. There's another person that I become friends with, Kristen Marie. And she can be the same way. She gets wound up and she starts peppering with messages. And I'm like, how the hell does she type that fast? And I can't answer. I know the answers to the questions, but I can't type them fast enough. And in the time that it takes me to type an answer, she types 3 more questions and keeps going. I'm like, oh my God, I can't do it. I'm too old for this. Bonnie says the feds handed 3,100 pages. Jackson could not disclose everything. Yes. Now, not only that, there were 3,000 pages, and the motion that was filed was 50 pages. So the motions that both sides, both the defense and the prosecution filed were 50 pages, and then they were only given 10 minutes. So he had to pick and choose what were the most important things in it. And they weren't going to try the case there. What they were going to do is show ways that evidence was presented to the grand jury that was false in a way that would have, that had it been properly presented, would have possibly changed their result. And what they presented was weak, in my opinion. But so maybe there's something else in there that they chose not to present for some reason, but why? I don't know. I don't know why. So to me, generally, the defense is going to fire they're going to use their bombshells. They're going to use their artillery. And I hate that word. I like to write it, but I can't say it. Artillery. There you go. They're going to fire their artillery. And if that's what they fired, it was not very impressive. Hi, Comfort and Joy. Good to see you. Higgins did not get fired or suspended or have his gun taken away. There were a lot of false reports out there. Patrice, thank you. Appreciate it. You know I love you. Charlie says, what do you call it when people are still in denial despite facing obvious facts? Well, you aren't going to like my answer, but I call them free Karen readers. Listen, we can all have a different reaction. I have friends that have a different reaction to what they heard Tuesday, but you have to not fall for these tricks. Stick to the fundamental foundational evidence. And nothing challenged the foundational evidence. If something did challenge that foundational evidence Tuesday, I absolutely would flip. Okay. So if you want to really make me rethink this evidence, if that's your goal, okay, if you want, and I'm open to it, I'm open to anything. Okay. If you want to convince me that OJ didn't do it, I'm open to it. Show me real evidence. If you want to show me that we didn't land on the moon, like some of the conspiracy people say, show me. I watched one of those videos once. They had some interesting evidence that showed they were planting a flag on the moon and it seemed to be blowing. And there's no wind on the moon, of course. There's no atmosphere. So I was like, oh, that's interesting, but no, we went to the moon. But I'm willing to look at evidence, and so practice what I preach. Yeah, I look at the evidence. But if you want to convince me, you've got to show me how GPS could be wrong on this. Okay. And you're not going to be able to do that. And I don't want to hear anything about Apple Health app data being better than GPS because it's not. Nothing is better than GPS when it comes to location data. Apple is it's a fine program. It's an extraordinary program to help you exercise. But if you want to send a missile 3,000 miles and have it go through a window of whatever, you're going to use GPS. You're not going to hook up a health watch to that missile. I mean, you're going to use GPS. That's what it was designed for. And you're going to see experts describe. Now, if you look at each one of those data points in the GPS, that's enough for you to say, okay, there was hypothetically 3 seconds where that phone could have been inside the house. But really, you can see the pattern of where that phone went all the way there, driving from downtown over streets. There's no point where you see it driving through lawns, cutting in between houses. No, it takes the streets there, comes to the street, turns, goes on to Fairview, and eventually goes down to the end of the road. And that's where John's body was found. So you can't get past that. Now, you can try to get past that and say, okay, was there some way that John dropped his phone and went into the house? That's theoretically possible, but it's a really difficult position to argue. because he was found on top of his phone. So maybe you could argue it if John was found far away from his phone, so he dropped his phone in the yard and went in and got killed, and they brought him out and dropped him on the body somewhere in the lawn. But he was found right on top of his phone. So isn't by far the most likely and plausible explanation that he had the phone in his hand when he was hit? I mean, so you really can't get past that. And then you get to the planting of evidence. Now, that's maybe so if the odds against the GPS wrong are 1 in 100 million, the odds of planting the evidence are much better. So the odds against planting that evidence, the odds of that evidence being planted, what is it? Maybe 1 in 10,000? I mean, it's something like that. I mean, there just was no time. There was no access to that vehicle. And the odds of being able to get out there and do it, burying it in the snow where no one sees you. And the DA has said Proctor wasn't there. So everybody else would have to play ball in this conspiracy. All the other troopers would have to somehow look the other way while you planted evidence and not say when the DA lied about you, and nobody cracks on this case. The odds are against all that, extremely against all that. Even to tamper with the vehicle. The vehicle was in the garage with his 24-hour video surveillance. So, I mean, it's just those fundamental things right there you can't get past. So you want to point to weird things. Why did Higgins go into work? Okay, apparently he does do that, and he had a cot there in a shower. But certainly at the beginning it looked like really weird, right? Why? Because his office was at the Canton Police Station. You want to talk about why didn't the Alberts come out of the house? Well, that bothered me a lot at first until I realized it's true that in these small Massachusetts towns, like I'm in one now, and I'm on a similar kind of street to Fairview, these guys, when they drive, and these when they come in the dark, the first responders, they don't come on with sirens on. So that fire truck and the ambulance and the police car that showed up there would have come in with no sirens. They would have come in silent. Now a fire truck has pretty loud engines, but there was a blizzard going. And when you listen to that audio that was left on John's voicemail through Karen's phone, you can hear the wind howling. So it's not really that surprising that people were just sleeping and had no idea what was going on outside. It's not, so there's a lot of odd things, and some of them have been explained satisfactorily now. Other ones will be explained in the trial. Now, we don't get to hear Trooper Proctor defend himself. We should get to hear that in the trial. We don't get to look at any of that evidence. We don't get to see any of that Fed stuff. We're actually not even going to get to see it in the trial, the Fed stuff either, I don't think, because it's very federal grand jury material is very protected. But we'll certainly see a lot more. And so a lot of these things, the library gap, that's going to have an explanation. It's motion triggered, and Karen didn't drive by the library going home. Simple, right? So there's going to be a lot of other evidence that we might see. Hopefully there will be an image or video that gives us a better idea of that taillight. And so what we really need to see, I think my best hope is that Karen drove by one of those cameras. So Cassie's Corner Convenience or the library, or the library would have been at 5 a.m. So it didn't pick her up the first time because she obviously didn't drive by it. There's a Jewish temple. There was a farm. There was some different things like that. And what we need to get is a side angle enough where you can see this. So the damage is not on the back of the taillight. It's on the corner of it, really, really on the side. And it will only show up, my understanding, it'll show up better when she hits the brakes. In that video of her in the driveway, she doesn't hit the brakes when the camera is facing the side. So you don't get to really get a great look at it. But to me, I'll show it to you guys again. I haven't brought this up for a while, but to me, that video seems to show pretty, not clearly, not with any conclusive clearly, but it seems to show a missing piece there. So let's see if I can pull this up for you in a second. All right. 1 second. You guys have all seen this, but you're going to see it again. This is a close-up. All right, let me take myself off. All right. This is a close-up that I made. Obviously, hopefully, the defense and the prosecution will be able to work some magic and get a clearer video of this. This is the best I could do, but I did zoom in on it. So this is, you see it right there. It starts to get white right there. See that white flash? We don't know what that is. Now, if you look in this picture here with the flash gone, you can see what looks like a white flash up top. So that indicates this probably is some kind of a spotlight on the garage. So when we go back, is that just a reflection? But interestingly too, even if it is a reflection, the part of the taillight that was ripped off was the outer red shell. And underneath, the white plastic was still intact. So this almost looks to me like, yes, it's picking up the spotlight, but the spotlight is reflecting off that white piece. And you notice where the red is still intact, it's not being reflected off that, or not very brightly. And also, it was kind of a corner that was missing. So there's a three-dimensional element to what is missing. And if you look closely at this, it looks to me like, if you look right below the red, you can see this kind of a corner that's missing. But again, you have to see what experts will come up with here. And, we're all guilty sometimes of we're seeing what we want to see, so, and you might think that's the case with me. I don't know. So we looked at this summer when it came out, and I had three other people on my team, and we had a Zoom meeting just to look at this, and we couldn't really agree, and we couldn't really be sure. And I still can't be sure, but I certainly wouldn't look at this and say, aha, one way or the other. To me, it looks like there's a piece missing there. So we'll let it play out. But unfortunately, she doesn't hit the brakes. So, and if I played the longer version, you would see that she doesn't, she hits the brakes later, but she's moved on. Just got a message. Let's see if there's anything interesting. All right. So I'm not sure what this is, so I won't check it. All right. So let's just check quick and see if there's any more important messages. Sorry, I got behind again on the chat. I do the best I can. I'm willing to share documents, anything that I have with anybody that wants it. My email is leitskev, LEITSKEV @gmail.com. My Leits goes back to my bar owning days. I owned a bar in Worcester called Leacham's Pub. So that's where Leits come from. Footage from Karen's parents' house. I mean, I don't know. I'm told that they don't have that yet, that they haven't turned it over yet, but I don't really know. Ghost 13. That's a new name. Good. Welcome. She hit the brakes later, like you said, and you can see her brake lights light up. Play the whole video. All right, I got the longer version I can play you if you want. Hold on 1 second. I do try to accommodate. All right, let's see. I think this is the longer one. Yeah. All right, hold on 1 second. All right, here we go. All right. All right, this is the longer version. So this is 5 a.m. Karen backing out. You can see it's snowing pretty good. I don't know how much snow you guys think is there. It looks like, I don't know, what do you think, 1.5 inches maybe? Hard to tell. Notice there's no, when she pulls it. Now notice some different things there. There's no other tire tracks there. So no one is driven in this driveway probably in the last hour, right? Possibly before that, but certainly in the last half hour, maybe in the last hour, no one has driven here. Because one of the theories is that she may have taken out John's car earlier to go looking for John, but if she did, she would have to have taken it out, say, at least an hour before this, or it would have left tracks in the snow, and we don't see any. Also, as she pulls away, there are no pieces near John's car, so no pieces were left there. And that's when the brakes go on. So, actually, I'm going to let this play out because I think I zoomed out. I think I zoomed in a couple of times. So you'll see it again. Definitely hits the car enough to move it. No question in my mind. Hard enough to do damage? Probably not, but hard to tell. I mean, it looks kind of like a missing piece there to me, and then when the lights go on, I don't know. You have to really, when the brakes go on there. So that to me looks, now keep in mind too, that where I identified the damage, this was like back in August when I made this video. So this was before we got any pictures that showed where the actual damage was. Those have only come out more recently. Those have leaked out from wherever. And now we have a clear idea of where the damage was. And it wasn't on the back. It's on the corner, really like the side corner. But I didn't know that when I was doing this, making these videos here. And so to me, that kind of adds a little bit of weight to it. The fact that I just happened to pick that spot. And then that now we know is exactly where the damage is. So Kevin showed Karen's car in the tow truck where the light is still intact. I don't have that picture. And the only picture that I saw on that doesn't really show anything to me because it shows it kind of from the back. It's not on. The lights aren't on. It's far away. I have not. So if you got a good picture, feel free to send it to me, leetskev@gmail.com. But I have never seen a picture that really clearly shows the condition of the light on the truck. Couldn't verify what? So good question from Wicked Psyched. And I've had, these are things that are great in these investigations. You come up with a lot of questions. So she says, why didn't investigators, people on the scene, tow drivers document or take pictures? And I don't know what the policy is, but this bothered me for a long time too. Like, man, doesn't somebody have the common sense to just pull out their phone and snap a picture? Right. That really bothered me. But as I've thought about it, I think these guys, they're spending all week. It becomes routine. You're doing an investigation and you're going through the motions of what you were taught. And your job as a lead investigator is not to go and take pictures. So you only do the things it's on your checklist of things to do. So putting pictures on your personal phone is not one of them. And carrying around a camera is not one of them. So that probably explains why. So I bet if you would, now we'll see, but I bet that if we ask Michael Proctor this, and if he's asked this at trial, he will say he's never taken a picture. And he's been on homicide for 4 years. And I bet he's going to say, I've never taken a picture of any piece of evidence. So why didn't the Dighton cop think to do it? Same thing. I don't think these guys really think of that stuff. So. Boston, Mass says taillight broken doesn't mean anything. Where the rest of the taillight is does. Well, I think the taillight, if you can get a picture a clear picture that shows either whether it's a still from a video or whether it's something else, but if you can get a clear picture that shows that this taillight was relatively intact, then you have a conspiracy. If you can get a picture that shows there was pieces missing, then she's guilty. And there is some other evidence that I can't, this is not from the police. So nobody violated anything. This is not even from a source connected to the police. That's all I'll say. But there is some other evidence that's going to be big in this case that shows that pieces were missing. Already before John's body was found. That's as far as I want to say on it. It's from a good source. It has nothing to do with the police. It's evidence that is now in discovery, but was not before. And that's how I was able to find out about it. But it's not for me to reveal it. So I'm not going to reveal it. The people involved will reveal it if they want to. But now I don't know. They may not be comfortable doing it now because now it's in discovery. Heather, that has to be policy to get a tow for anything. They document everything. I don't know. Does the tow truck guy document that stuff? Those guys don't do anything that they don't have to. So, and this wasn't like something for accident insurance purposes. This was a homicide investigation. So, yeah, Victoria, I'm completely serious. You don't buy my explanation? Look, do you think, let's put it this way, Victoria. Do you think that when they get Michael Proctor on the stand, if they were to ask him, have you been on homicide for 4 years? How many pictures have you taken? What do you think he's going to say? And if they ask him, how many pictures have you taken with your personal phone? What do you think he's going to say? My guess is it's going to be 0. I'm willing to bet you a bottle of scotch on that. My guess is that Michael Proctor has never taken a picture at a crime scene on his personal phone for the purpose of evidence. Now, I have never got that question to those guys. I have no idea. I've never seen if anybody's asked that. So that's just my hunch. But that would be my understanding. That's why they didn't take a picture. That's another team that does that stuff. And so their job is just to, the search team documents everything they do at the crime scene. And then you have the chem team that once you get the in this case, the murder weapon, the vehicle back to the garage, they go over that over a period of whatever, many hours, if not days, to find out all the evidence, any potential evidence. So blood, fingerprints, DNA, anything. Alyssa Adams, no, Kevin, he is supposed to take pictures. Okay, I don't know. So somebody find out some source on that and get back to me. But my guess is you're going to find out. So are you basing this on some source, Alyssa? Do you have police training? Do you have some indication of what the training is for state troopers on homicide or on anything even else? I mean, I'm not saying you don't. Maybe you do. I don't. And my guess is they don't. So this is a really good question, but I don't have, we don't have access to this information. So Kevin, check out Proctor's investigation of Brian Walsh and compare it to this investigation. I'd love to, but I don't have access to any of that material. If you want to give it to me, I'd love to look at it. But keep in mind, it would take a long time of looking through that because I've been looking through this evidence, and many of us have since April. So we've gone through this material for a long time. So we, even something like, say, the charging document, I had to read it several times over. And even if I was to read it tomorrow, I'd probably still note something new that I hadn't observed as meaningful before. It's a really, so I would like to see it, but I don't think any of us has seen anything that we can compare to. We don't have that level of stuff. So. See, Victoria, maybe I won't unblock you because you know what? You might be able to get a job working for Alan Jackson because you mischaracterize words. So you said, so Michael Proctor, why didn't you take pictures? It was a long week. That's not what I said. What I said was he's never done this. That's my guess because that's not what they're trained to do. Okay. They're not trained to use their personal phone to gather evidence on. Because then the defense is always going to want access to their phones. And as you can see, they don't want that, and you wouldn't want it either. So, I mean, I don't think that it's just not on their checklist of things to do, to go to a scene and take pictures with his personal phone. So now you can say maybe they should have had Are there cameras that are designated for them? Is that normally part of their evidence gathering kit? I mean, I don't think it is for the lead investigator, but these guys, it was during a blizzard and they had to share a car. I think they got a mechanic's truck to go make the drive out to Dighton. This was the biggest blizzard we've had in like 5 or 10 years. It was a pretty good blizzard down there. So, I mean, to think that he's going to be out there taking pictures on his personal phone is probably not reasonable. It doesn't happen. Megan Mahoney, you frustrate me. Oh my God, Kevin, cops take pictures of every significant thing they deal with. Good God. Do you know this as a fact that homicide investigators for the state police do this? Okay, because you can't say this. You can't just get your information from watching old episodes of Columbo. Okay, you can't just base your information on what you think they should do. Okay, none of the Canton police took pictures, right? Because they're not trained in that kind of evidence gathering. They don't have a homicide unit. And then when you get to the state police and you have a homicide unit, everything is broken down into specializations. So you have the CERT team. I don't know how many guys it is, say 4 or 5 guys out there at the scene. You have the chem team going over the car. You have the cars team that after the chem team is done, goes and takes apart the car. Who knows how many other teams are out there doing their thing. Each one has their role and they're trained to do things. The lead investigator is out to ask questions, talk to witnesses, and get the investigator like that, and eventually put together the evidence into a package and sign it up and send it up to the prosecution. Now, so I'm going to guess that no, they have no, but if you can tell me otherwise, don't just say, OMG, show me some evidence. Show me what you're basing this on. And it better not be some old episode of Hill Street Blues. You have to show me how it is that lead investigators on a homicide investigation for the state police in other cases go around and take pictures. Cite some example. Go and find some example. Cite some example. Come back and show it to me, and I'll be glad to eat my words. And I will do whatever it takes. Have you on the show say, "Oh my God, I'll be the OMG." Like, OMG, Kevin was wrong. I'll do it. Okay, but right now you haven't impressed me with that. All right, guys, it's getting late, so please don't take it to heart. People like Megan or whatever. I mean, I push back a little bit. You push at me. It's okay. So it's not personal. I know you're good people. I know you care about justice. So please don't take it in any way disrespectful. So I pretty much have to call it a night because I'm tired. It's been a long night, but it's been a good show. If anybody that's out there wants to give me at least a little bit of support, go over to this. Right now, there are 1,210 people watching on Twitter. So please head over to YouTube for 1 second and just click subscribe because I want to get my numbers up to 5,000. It's a very small goal. And for people, someone like me who's just trying to ask questions fairly and take questions from both sides, you don't see anybody on the grifter side doing that. You don't see Aiden doing it. You don't see Sean doing it. You don't see LTL doing it. You don't see the Jellyfish doing it. None of these guys are doing this stuff, So if you want to see questions and discussions from both sides, I wish you had more options than me, but unfortunately, I'm the only option you got. So please support it and go out and just, give me a subscribe on YouTube so I can hit that really small, but for me, meaningful number of 5,000 subscribers. It doesn't cost any money. You just hit the subscribe. So the next big thing on this case is on the 20th. I'm going to get on Saturday night and do some more in detail report on the Delphi murders. And we'll compare it to the Karen Reed case because there is some interesting stuff. Like I mentioned earlier, they did geofence data and there were some phones. There's a lot of stuff in the document that I just read. The defense has a motion complaining about the prosecution, possibly some Brady complaints and stuff like that, where they don't think evidence was turned over. So this is how it works in the trial system, So that's what we're going to do, and I'm going to look at that. And some of this stuff might be relevant here because you got the geofence. You have what the defense will say is misconduct because you have phones that were identified near the bodies or within 60 to 100 yards of the bodies, which were the bodies were out in the woods, and you're going to see that that some of those people were not interviewed, and it was not explained why. So the defense is rightfully highlighting that right now, right? So I think it's really interesting. So we're going to go over that, and we'll come back and compare it to this case. But again, thank you guys for being here. I appreciate it. And did I thank everybody that, yes. Oh, Kathy, also thank you. And Pat, thank you guys for the contributions. Much appreciated. And it's Thursday. We're heading into the weekend. For some people, it actually will be the weekend. So enjoy your weekend. Hopefully you have tomorrow off.